The Drake Group Education Fund is dedicated to educating the public and professionals in our business with fact-based information featuring the experts in our profession, so that we might all do a better job of helping college athletes realize the promise of an educational degree and becoming all they can be as students and athletes. So we welcome you to our 50-second webinar. Thanks to all of our panelists for their time, expertise, and ideas, and to all of you for attending. Webinars provide us with the opportunity to share new ideas, recalibrate our thinking on issues, and get up to date on important topics. We are so pleased to have you join us. Lastly, before you meet our moderator and panelists, I just want to emphasize that our speakers are expressing their own opinions and not the opinions of the organizations in which they're employed or are members, unless they make that distinction in their remarks. Now, I'm honored to introduce the moderator of today's program. Please meet Dr. David Ridpath, a leading scholar on intercollegiate athletics governance and administration, a tenured faculty member with Ohio University and its prestigious sports administration program as a professor of sports business. He is also the author of multiple books and has published extensively on NCAA policy, ethics, and college athlete outcomes in peer-reviewed academic journals. All yours, Dave.
So I'm off mute. Yes, as always, I never check that. But thank you very much, Julie, and Merry Christmas, Happy Holidays, and Hanukkah to everybody out there. If I forgot a holiday, I apologize. But as Julie mentioned, I am Dr. B. David Ridpath. I'm a professor of sports business at Ohio University and a longtime member of the Drake Group and the Drake Group Education Fund. It is my pleasure to moderate this webinar today with our outstanding panelists. We are covering a very important topic today. How will NCAA rules be enforced going forward in this new world of intercollegiate athletics? The longstanding NCAA enforcement and infractions process has been praised and maligned for decades, but it has also made many changes to make the process more efficient and fair. However, the process has been consistently challenged legally and politically, specifically legally in the courts recently, with many athletes gaining extra years of eligibility. And just a few days ago in Alabama, an Alabama court barred the NCAA from enforcing its show cause provision on former Tennessee head football coach Jeremy Pruitt. One thing is guaranteed going forward as we sit here today. This process will change even more, perhaps more than it ever has. But how it should change remains to be seen. Can NCAA membership-driven rules actually be enforced when the rewards of winning and revenue generation often outweigh the risks of breaking those very rules? Considering that the former holy trinity, as I call it, of NCAA rules enforcement, recruiting, eligibility, and financial aid have essentially been dismantled in this new non-amateur intercollegiate athletic space. The days of punishing athletes for extra and monetary benefits above a full scholarship of tuition, room and board, books and fees are long over since the advent of the cost of attendance stipend, NILs, and revenue sharing. Recruiting restrictions themselves were always difficult to police at any level, but now it seems to be virtually impossible in this new environment. And it is somewhat unknown what those restrictions in recruiting even are. Some of the few things left for the NCAA and its enforcement system to police seem to be constrained to things like academic eligibility, gambling, and playing in practice seasons, just to name a few things on an ever-shrinking list. Given that NCAA enforcement is progressing towards now a somewhat bifurcated system, where the newly established College Sports Commission will police athlete compensation, revenue sharing, monitor name, image, and likeness deals, and also roster management, which essentially deems the CSC as the primary enforcement agency for this new era of paid college athletes. Given that recently, numerous schools and states led by Texas have roundly rejected the recent CSC proposals for enforcement of the new intercollegiate athletics environment, specifically regarding NILs and revenue sharing, where exactly do we go from here? What is the role going forward of the NCAA enforcement staff and the Committee on Infractions. What exactly will they enforce? Will they or can they interface with the CSC and the enforcement of rules? What of the CSC? Will it be able to develop a workable framework to actually enforce rules that many in college sports claim to want? We have many questions and hopefully some great ideas and answers. I think I can speak for the panelists in that we support governance. We support enforcement of rules in college sports. And like anything else, there needs to be boundaries and controls defined. How we get to this aspect might be the biggest question of all. Well, enough for me. I want to get to the panelists. I will give a quick overall introduction and then give each panelist 2 to 3 minutes to give their overall take on the current state of the NCAA enforcement and infractions process, along with initial thoughts on the College Sports Commission and how we might be able to move forward with some semblance of governance and enforcement. Then we will move on to questions from me. I will direct traffic from there. And as Becca mentioned, we will leave hopefully a good chunk of time for questions from you. So please send as many questions as you can, and we will address any missed questions in our follow-up notes after the webinar. Now, we have hit a virtual home run with this panel who is more than qualified to speak on these issues. In fact, I'm the only one on the screen, I think, who is not a lawyer. We have a former chair of the Division I Committee on Infractions and Professor Joe Patuto. We have a former member of the NCAA enforcement staff in Libby Harmon. We have a current NCAA faculty athletics representative, Rick Karcher. We have the former athletics integrity officer at Penn State, Bob Boland, and prominent sports law attorney, Donald Maurice Jackson, who has appeared before the COI many times representing individuals in front of the Committee on Infractions. So without further ado, I thought, let's go with protocol here and have Joe Patuto open up and give her opening statement on where she thinks the state of NCAA enforcement infractions are today.
Well, I hate to open up as a Debbie Downer here, but I do think it's a mess. And I don't think it's just enforcement infractions. I think it's the entire regulatory system of the NCAA. And I don't think what we're doing right now is sustainable because the courts intervene on every single regulatory effort. Now, some of them may have been ill-advised, some of them may have been self-serving to universities, but you cannot have a system of governance where you cannot govern, and every time there's a decision, some court somewhere puts it on hold. And that's where I think we are right now. So I don't think the issue is enforcement infraction. I think the issue is the underlying rules, what they are, what they should be. You can construct enforcement infractions if you know what the rules are going to be. And we've got a double problem right now. We cannot articulate the rules because of the antitrust oversight that keeps interceding. And if you can't articulate what the rules are going to be, there's no way anybody can enforce them, and there's no way any adjudicatory body can adjudicate them. That's where I think we are right now. And I think it laps over into all kinds of things. The CSC, as I understand it, is an attempt to exempt the schools from antitrust oversight, which is a noble effort. But at the same time, trying to bifurcate rules governance seems to me to be at least iffy. The NCAA has tried at least twice that I know of in the past, and both times they've abandoned the effort because it's very difficult. Rules interact with other rules. And if you're doing something in NIL, what does it do to academic eligibility? Or how does an academic eligibility decision affect an NIL contract? So I'm willing to see what the CSC wants to do, but I don't go in with a very hopeful view of it. My bottom line is we have been avoiding and trying to avoid some sort of federal legislation to get a national norm and standard for I can't tell you how many years. And it may be difficult to move the Congress to do anything, but I think ultimately that's what we need.
Okay, thank you, Joe. Don?
Okay, thank you, David. I come at this from a entirely different perspective representing the interests of coaches, quite often student athletes, and universities as well. There are some, and I agree with Ms. Patuto, there are some basic underlying issues that impact the entire regulatory structure of the NCAA. At the top of that list is the fact that student athletes have no due process protection. They don't have a property interest in their athletic eligibility. That trickles down and it impacts the system in a number of ways. From a coaching standpoint, it's been my opinion for now for over 3 decades that most coaches don't wake up in the morning with an intention of violating NCAA rules. Some do. I won't deny that. But generally speaking, the best enforcement strategy, I believe, is education. And when a rule structure is so complex, and now with the current system, there's been a refinement of the regulatory system and to simplify things. But still, when a regulatory system is so complex that people at the lower end don't have a basic understanding of the rules, that's a system that's dysfunctional. It's a system that will ultimately generate issues on the enforcement level. I will be frank with you. After having been in this industry for over 3 decades, representing stakeholders at every level, the degree of faith and trust from the standpoint of student athletes, coaches, and frankly, from an institutional side, there as well is low. Coaches that go in front of the enforcement staff believe that they're going to be deprived of basic rights. And let's just be perfectly blunt about this. A system where when you go in front of the Committee on Infractions, where there's no set burden of proof or standard of proof. In a criminal case, it's beyond a reasonable doubt. In a civil case, it's preponderance of the evidence. In a Committee on Infractions case, and I had an enforcement staffer acknowledge this in a brief in front of the Infractions Appeals Committee several years ago. There's no set standard of proof. How can anyone go in front of the Committee on Infractions and have a comfort level when they don't even know what standard of proof they're going to be addressing? So it's my hope that this commission will have a favorable impact on the regulatory scheme. But I've seen the basketball focus group. I tried several cases in front of the IARP. And a number of cases over the years, over the past several decades, in front of Committee on Infractions. Last thing, a real indication of the dysfunctionality of the Committee on Infractions structure and the enforcement staff structure was pointed out to me 20 years ago in a case that I was involved in under the old system. I represented a coach at a low major school, football coach. In 2005, the school owed him several $100,000. He was only guilty of secondary violations. Secondary. Everything, we got him cleared of everything else. The school went in front of the infractions committee in October of 2005 and attempted to convince the Committee on Infractions to recharacterize a secondary violation into a major violation. Have you ever seen a school say we're not guilty of jaywalking, we're guilty of capital murder? They did that in order to justify terminating a contract. Luckily, they lost. It's a regulatory system that is now in a state of chaos. Thank you, David.
Absolutely. Thank you, Don. Let's go to Rick Karcher.
Hey, everybody. First of all, I want to say I appreciate being involved here, this webinar. Look forward to having a great conversation with my colleagues here. Unfortunately, I can't communicate with the audience, but too well. But I'm not one who tends to think that the sky is falling, and that may be a surprise to a lot of people because everybody thinks there's chaos, and I never use that term chaos. I think that, or my perception of NCAA enforcement is always one that looks at history and it always looks at the NCAA manual, and in particular the Division I manual, because that is the governing document that guides the NCAA and its enforcement process, as well as all the obligations of the member institutions. The NCAA, when we say that, what we're really saying is the member institutions. The member institutions historically have never been satisfied with with any enforcement process. This is nothing new. If you go back to 75 years ago, NCAA, when conferences were being formed, the conference was essentially one of the reasons the conferences were being formed is because to remove a lot of the political burden away from the member institutions. And so the member conferences, or the conferences, started acting as the enforcement of the rules that were in place. And the institutions didn't like that. And there was a lot of fighting when the conference, within intra-conference, that is, among member institutions, when the conference was the enforcer of the rules. And so then they decided, as institutions, as the NCAA came along, let's create an enforcement division. And then they never liked the enforcement division or what the staff was doing, including the infractions committee. So they created, an appeals committee, and they didn't like those results. So they created something called an IAAR or whatever, independent term. And so we go through all of these iterations throughout the course of time, and nobody's ever satisfied, okay, with the enforcement process. And that's okay, but that's just part and parcel of, a situation where you have hundreds of member institutions and, a good number of conferences operating at different competitive levels. So I guess the last thing I want to say here before we move on to the next person is that, we've lost sight, and this to me is what it all boils down to. We've lost sight of who is supposed to determine these rules that we're all talking about and what we want to see or not see or what our opinions are of them. The member institutions are the ones that are supposed to be creating the rules, and that's not happening anymore. What you have some individual, some committee, or some board decide something, and then everybody goes, okay, and they don't. The way it used to be was, and I used to, I've taught compliance for years, and I've known a lot of compliance people. You get your 20-page document of, rule change that you want to propose, and you do your strike throughs, and you revise the provision in the manual, whatever rule it is, whether it's an amateurism rule like NIL, or whether it's, something related to enforcement. And then, there's a rationale that somebody writes on it in terms of why we're changing this rule to say what it is. And then everybody got into a room at the NCAA convention and they all voted. Okay. And then they approved it or they didn't approve it. Now that changed. And that is what really needs to be focused on, because that was a significant change. And we saw that really starting in 2021 with the adoption of the interim NIL rules. And, so, if you think about NCAA governance, that term governance, it all revolves around institutional control. And a lot of people have forgotten what that means. And I'm just going to read it to you right from the manual. It actually shows up in 3 different provisions. It's so important that it's in the Constitution and it's in the operating bylaws, but it's real simple. It says that the control and responsibility for the conduct of intercollegiate athletics shall be exercised by the institution itself and by the conference, if any, of which it is a member. Administrative control or faculty control or a combination of the two shall constitute institutional control. We have a situation today where people are losing sight of that as well. people, meaning the schools themselves. Okay, when you have schools that are actually helping to finance a player's lawsuit against the NCAA over an eligibility rule, we've literally lost institutional control. Okay, so I'm going to come back to that issue in this webinar later. So appreciate it.
All right, thank you, Rick. Libby Harmon.
Thanks, David, and also want to thank Julie and the Drake Group for putting together this webinar. The stakes are higher than ever in college athletics. And as mentioned, the forces at play that have narrowed the enforcement staff and the Committee on Infractions scope significantly from where it was, just a few years ago. Of course, the enforcement staff still remains the traditional enforcement authority for what I'll call your non-House and non-NIL, for the most part, issues in Division I, as well as still has authority for Divisions 2 and Divisions 3. I would say of late, we've seen an increased focus by the enforcement staff, particularly on sports wagering, and we've represented dozens of athletes in those types of infractions and reinstatement matters. Given the proliferation of the popularity in legalized sports wagering and access to student athletes through social media, I would expect to continue to see these issues rise, and the enforcement staff and the committee to be continue to be involved in those decisions. This is a fast-paced environment. It's evolving rapidly. We saw just yesterday there was a prediction market entity that announced it would offer prop bets tied to student athlete transfer decisions before walking that back under public pressure. So I think this is a continued area of concern, certainly for the membership, and as well that we'll see activity from an enforcement and Committee on Infractions perspective. The CSC is an open question, as people have already said. Whether it becomes an effective enforcement mechanism, of course, remains to be seen, and the scope, certainly of their duties, and the interplay between CSC and the enforcement staff, when inevitably you're going to have overlapping issues that they both may handle, and how those are addressed. Looking ahead, of course, there's many other factors that have already been mentioned. Is there going to be congressional intervention? I think it's likely to expect continued legal challenges for some of the unresolved issues that are affecting college athletics, employment, collective bargaining, eligibility clocks, Title IX, et cetera, as well as how conference realignment and media rights deals kind of continue to shape college athletics, as well as who is making the decisions when it comes to your regulatory systems, your enforcement, and your governance.
Thank you, Libby. And last but not least, Bob Bolin.
Well, thank you for letting me go last, Dave. And that was a particular honor, but also I think gives some opportunity to talk a little bit about our basic ideas of governance. And I come at it from a unique perspective, having been an athletic integrity officer, ostensibly a fiduciary of the NCAA on a campus in a unique circumstance. But the idea that that was an important piece of NCAA process that's largely been pulled back from, I think, is a unique idea. But my thought about governance is that governance generally derives from the consent of the governed. And we are in a place right now, as some of the other panelists have arrived, that the NCAA has remained in the same place while the world has moved forward around it in a variety of ways. That the institutions see athletics differently than they once did. The athletes themselves, who have never had a voice in 120 years of NCAA governance, now are seeking that voice and seeking that from courts. And we're seeing new influxes of investors into this model, whether it's private equity or other things. I think my day-to-day is a perfect example of that. I was supposed to be in an eligibility hearing in a court that was postponed, at least this morning, and I'm going to leave here from this panel and go talk to people about private equity. So it is an interesting day that we're having in this space. But I think that the NCAA has not with enough notice taken enough steps to understand what the will of the governed is or how it should be manifest. And I think Rick talked to that point pretty interestingly. Is it institutional goals? Is there a consensus that needs to be arrived at between the athletes, the people involved, the stakeholders, the coaches, and others? Is it an entity like the NCAA that is trying to make their rules? And I'd probably highlight two particular things that are consistent to me with that lack of consent in this case, which puts them out of step with where we're at today. The first big piece of that lack of consent is the House settlement and its progeny was entered into by a group of lawyers without really institutional feedback and with only 5 or 6 defendants at the NCAA and the 5 power conferences. And those rules were then brought to everyone else as part of a new consensus negotiated in a courtroom in Oakland. The CSC, in the same way, I guess part and parcel of that same consensus, is being imbued with powers that are structurally complicated, that are contracts of adhesion that institutions are being asked to sign right now and give away rights. So rather than moving forward into this, I think, bold new future of, and I don't particularly love the professionalizing model. I think there is something unique and special about college athletics. And I think you said it. I think Don said it. I think Joe may have even said it too, that one of the most important parts is that it is part of an academic model, that it is a thing that is a part of that. And I don't think we talk nearly enough about this. And maybe that is the one thing we should be remembering, that maybe that's the power of the NCAA, is to maintain some version of academic and educational integrity and with a goal of completion of degrees and outcomes in that space, but outcomes that are modernized to the idea that people go to school 5, 6, 7 years now, that people earn money from this, that these are opportunities. And rather than trying to turn the clock back in the House settlement, in the SCORE Act, or in the CSC agreements to an earlier time when power was held but between the institutions and the NCAA, with maybe more of a focus on the NCAA, this should have been a much more shared governance model that moves us forward. And that's our problem right now. We don't have a clear model because we can't reach a consensus of what athletes are. We don't have a clear model because the institutions now want different things than the NCAA itself does. The CSC wants to survive in its own way as an entity or a future bureaucracy, and is a governance model. So it's a complicated process we're in, and I hope I haven't used too much time. But the reason we're nowhere or are not in a place is that we're not making an honest effort to find where the world has moved from where we've remained.
Okay, thanks for those statements. I see already that Joe has a question, so we'll just move right to her.
Yeah, well, thank you. I agree more or less with it, with everything that was said, and I certainly agree with you, Bob. And we started out with the comment that the Drake Group was to see that the students can be all they can be as students as well as athletes, and we're missing the student part, at least in a predominant sense. But it's the antitrust oversight that gets us there, because that doesn't look at the educational component. It doesn't look at the academic component. It doesn't look at do students graduate or not graduate. It looks at the economic model exclusively. And I agree with you, Bob, and I agree with you, Rick, that we should be looking at what the institutions want, what student athletes want. But I think when we try, we end up with issues with the antitrust law saying you can't collectively do it because there's a competitive consequence to it that the antitrust laws won't let us get around. And that's what I thought the CSC was trying to do. If you buy into this, you've got antitrust protection. That's why I thought that was the linchpin of that House settlement.
But it doesn't look like they're going to have agreement for that. No, great points. And I appreciate that. Yeah, does somebody have a comment on that?
I do, Bob.
Yeah, go ahead, Don.
Before we go on, and I agree with Ms. Patuto to some degree. However, there's this one problem. Historically, all of the legal challenges to eligibility rules, rules involving athletic financial aid, rules involving extra benefits and impacted student athletes and sometimes even coaches and universities. Historically, those rules, the defense from the NCAA standpoint has always been these rules deal with eligibility or with issues that are beyond the consideration of the purview of a court. As a result of that, the only real way to get into court for plaintiffs, for student athletes, in the House case, in the O'Bannon case, was to pursue causes of action under Section 1 of the Sherman Act. For my law students, what I always tell them is when a plaintiff walks in the door in a sports case, you've got to make a determination first off as to whether or not they're part of a protected class based on race, gender, sex, religion, or otherwise. Or if they're not a part of a protected class, you have to find a way to challenge the legislation outside of a direct. You've got to take the NCAA out of their playing field and put them in a court system. The idea of the NCAA having an antitrust exemption, it's scary. In the same way that it would trouble me if they had an exemption under the Americans with Disabilities Act. And we also know back in 1998, they had to enter into a consent decree with the Justice Department because they violated the Americans with Disabilities Act. So I do agree with Ms. Patuto that to some degree, no, not to some degree entirely, student athletes are a secondary part of our consideration. They're a secondary part of this new commission. They were a secondary part of the IARP. They were a secondary part, collateral to the basketball focus group. But the only protection that they have is through the legal system, whether that's state or federal.
Can I make a quick comment here?
Please.
David, about lawsuits. Okay, first thing is no court has changed the NCAA governance process. No court has really changed amateurism. I mean, I don't want to spend a lot of time talking about court rulings, but it does relate to when you're talking about individual lawsuits or individual player lawsuits against the NCAA. Here's a change, and it revolves back to institutional control obligation. When you get a court ruling on a preliminary injunction, and I've been involved in these. I was involved in the Oliver case. I was involved in the James Paxton case. I've been involved in some other ones. Look, every single time a court rules in favor of an athlete in a preliminary injunction case ruling, all that judge is doing is saying, okay, NCAA, you can't, I'm going to say you shouldn't be able to enforce this rule, or they'll put some other kind of spin on it and say, the likelihood of the merits are such that I think this case might have some legs. We'll see, maybe there's a claim and we'll resolve it. But at the end of the day, the institution decides whether they sit the player or they allow the player to play. And that's all we're talking about. The way it used to be back in the day, we've always had judges rule in favor of athletes in preliminary injunction cases. Okay. What used to happen was the institution would say, well, that's fine and good, but we're still going to enforce the rule because we have an obligation of institutional control. And unfortunately, you're not going to be able to play until we get this resolved. The athletes still got their scholarship. They weren't kicked out of school. It's just an issue of whether they can play or not. Today, it's different. Preliminary injunction comes down in favor of an athlete. School says, okay, and then they play them. They allow them to play. They're not exercising their institutional control obligation. And that's all that's happening. But we don't look at it that way from the outside. We want to look at the rule and we want to say, oh, is the rule fair? Should it be struck down? This is outrageous. This is a possible antitrust violation, and the sky is falling. But we really don't have any court rulings that have said that these amateurism rules we don't even have a ruling on NIL from a federal court of appeals that says anything about it. So, that's why I started this saying the sky is not falling. I knew this discussion was always going to come back, in my view. Everything we talk about is going to come back to institutional control obligation, and that's not something that the schools want to talk about today. So,
Rick, institutional control. There have been cases going all the way back to the Lonnie Shelton case back in the 1970s at Oregon State, where Lonnie Shelton went to court and got an injunction to play, and Oregon State played, and the NCAA attempted to come back and impose a restitution rule against
sure.
and punish him for playing. So there have been cases like James Wiseman at the University of Memphis issue. So I agree with you that has been the case. But the difficulty and this one other issue, Smith versus NCAA, was a case involving a female student athlete that had graduated from one school, went to another school, attempted to play, and she essentially challenged the NCAA and said that they're not allowing her to play at the second school as a graduate student was violated Title IX. So she lost. But ultimately, the NCAA changed that rule and allowed graduate students to play. And it was a direct byproduct of that case. And we've had other cases. The transfer portal is in place because of litigation. It is in place. We have a transfer portal because of litigation. If a number of attorneys general had not gotten together several years ago and challenged the NCAA, we wouldn't have a transfer portal now. I was involved. David and I were talking about a case before everyone got on the line. I represented a player back in 2015, Austin Nichols. He was transferring from University of Memphis. And at that time, I represented all these players in transfer fights. And at that time, that was the first time that I openly talked about the fact to the news media that transfer restrictions violated federal antitrust law. I always got players cleared. So I disagree with you on this point, and then we can move on. Litigation does help to reform the process.
Okay, Don, I don't disagree with what you're saying, Don. Those are the member institutions that have gradually changed the rules. Okay. And so what I said was that a court and a judge, they have not changed the rules.
Listen, Rick,
And
I
so,
agree with you. Institutional control is where we should be. There's no question about it. In a competitive environment, institutional control at many schools is difficult to achieve. And I agree with you. You haven't said this, but I'll agree with you that that's wrong if it happens. But I don't think, and I guess I'm doing more macro because I don't think the NIL and revenue sharing are sitting on an island by themselves. The oversight of the court has meant that transfers, which I think, Don, you were right about, now they can transfer as many times as they want, and the academic consequence to them is really severe. All the research is you can be the best student in the world. You transfer once and your likelihood of graduating goes down. A lot of these kids are not achieving at that academic level, partly because they're spending so much time on the sport and then they're transferring and transferring. I talked to an academic services person this morning just to ask him what it's like now to work in that area. And he's someone who genuinely worked to get athletes graduated and not to just keep them eligible. And his stories this morning, I'm not going to repeat any of them. I mean, it's really, really tough. And the antitrust laws are getting in the way there too. I'm not advocating for any particular congressional solution. And Don, I'm not advocating for schools should do whatever they want. But unless there's something that allows schools collectively to adopt a rule that they think is in the best interest of athletes without the fear that somebody's going to sue and overturn it. I just don't see how we're going to get out of it. That's where
I'm sorry.
Joe,
Bob had that. Yeah, go ahead.
I think Joe is exactly right, except the mechanism or the intent to those changes has been ill-advised. And I'm probably in Don's line of thinking on that.
Right.
When the NCAA was asking for antitrust help, they didn't go to the Congress and ask for 5 years look in or 4 years look in on the SCORE Act. They asked for 125 years look in as part of that. And that made it a preposterous ask at that moment that even the schools and the group of six ADs and others had to kind of say, I don't know if I trust these guys with that against us. In the same way, when CSC asked for buy-in to draconian measures and new punishments, we're turning the clock back to 1959 in a way that seems inarticulate to the present moment, where this is a professionalizing environment around NIL and not recognizing what our priorities are. So I do agree that the NCAA's scope of enforcement has definitely been diminished in the present moment. And I think they recognize that by antitrust. But I don't hear them, I don't hear the NCAA as a whole and the member institutions probably in the same way, saying these are the things that are important to us that are academic. These are the things that are important to us that are about degree completion and a better life, and the things that we advertise in the NCAA tournament in March about all those great values of professionalism. And because we then either want to punish or constrain other schools or limit access to the courts, we're finding that the enforcement mechanism looks a lot like the great and powerful Oz, and we should pay no attention to that man behind the curtain. And if we get on the wrong side of the great and powerful Oz, we have to go to court to find a way to get back. And I mean, that's one of the challenges I think we're in. And I'm always heartened in this moment that I won't name this individual for fear of naming them, but they said when we undertook a project of reform, we sought antitrust counsel first. And I think that's one of the things that we know the antitrust applies as a center of gravity. We know that congressional action applies. We also know that there's a potential workaround around employment too. In this context, although I'm not sure I like any of those solutions individually, but we haven't talked together about the solutions. We've had parties talk, and the political parties have talked from their point of view. There is a solution set to be had here on priorities which we can agree on. We shouldn't enforce those priorities on everybody who haven't had a chance to agree on those.
Yeah, let me really great comments. Libby, we haven't given you a chance to respond. I see you have your hand up. So let's go with Libby, and then we'll jump into some of the questions.
Well, yeah, briefly, I mean, part of the issue is that student athletes' voice has never been part of the process as to what the rules are that they're supposed to abide by. You have adults who are making the rules for them. And we've seen over the past 5-6 years a lot of movement for athletes' rights in this process, good and bad. But I think what gets lost, and something we all agree on, is there's also a difference between who we're talking about, a difference between your men's basketball athletes and football athletes. Maybe I would put women's basketball up there as well. And then the rest of your sports, and how all of these decisions and changes impact college sports as a whole. Some of these are good for some athletes, and I think some of the decisions may be less good for some athletes and their sports, and the purpose and the goal to get an education and a degree. Because as we know, as a former track and field student athlete, most of us aren't going to go play professionally. Now you have an incentive to stay in college. So there's lucrative NIL deals, but it's still valuable to get a college degree. And I think that is the parity in college athletics right now, is it is a billion-dollar entertainment business, joined at the hip with higher education, and those often conflict, and it's hard to meet everyone's needs when you have so many different needs under a single umbrella.
Libby, you're not high on Grand Slam track?
Well,
they don't.
Go. No, that's fine, Libby. I'm sorry. You can respond. That's fine. Thank you. Well, we'll move on to some of the questions. And I did want to start off first with Bob and Rick, but I wanted to talk to and then have everybody have a chance to give input. Something's kind of near and dear to me. But what about the boots on the ground, the people that are at the institutions? Certainly, Rick and Bob have been there, but the area of athletic compliance. How will institutional and conference compliance offices function? Excuse me. Going forward, how are they functioning now? The traditional ways of institutional control and monitoring compliance functions has dramatically changed. What's the role going forward? How will compliance reinvent itself, or people who work in compliance reinvent themselves and focus on a more narrow scope? Or will they be more involved in NCAA or even CSC enforcement? We'll go ahead and start with Rick.
Well, my initial reaction to that question is just that compliance people, at least in my experience, everybody I've ever come across in compliance, they have a job to do, right? And their job is to, make sure that their staff, their coaches, their student athletes, their boosters are, doing things that are in compliance with NCAA rules. And the NCAA rule book, provisions change over time. And I will say something, again, I think it's tough as a compliance person today, um, when and if this continues, where the higher ups are don't view the their obligation to comply with NCAA rules at the same level of importance that it once used to be, right? Secondly, if member institutions are not creating the rules and have no input or say in what the rules are, that to me creates somewhat of a situation where, you know, why would I feel so strongly about institutional control when we don't even have any say over what the rules are? I don't know. That David, that's just my initial response to you is I think that compliance people are just trying to keep their head above water and comply. They're not thinking about the CSC. They're not thinking about the NCAA enforcement staff. They are just trying to interpret rules and get interpretations from the people at the NCAA when needed about what a rule means or doesn't mean. The last thing I will say about it is, you know, schools are sometimes caught, and compliance people are sometimes caught between a rock and a hard place with, athletes today and the rules, right? They've developed relationships with their student athletes, and you know, there's a lot going on today, with college athletes, and and in conflict in a lot of ways with what maybe the NCAA rules say. Um, and I think if I was in compliance myself today, that would be an uncomfortable situation, to somewhat be navigating.
Yeah,
Um,
very much so.
I don't want to get into a lot of specifics on that, but
Sure.
I think generally you maybe understand what I'm getting at.
Sure. No, it'd be very challenging. And Bob, I was struck, and I'm paraphrasing what Joe said earlier, but something to the extent of we can't govern effectively if we don't know what the rules are going to be or what the rules are. What do you think, Bob? You were there, you had boots on the ground at a very prominent institution. What do you think is going on now, and how is it going to be going forward?
I think Rick said something very profound in response to that, and I'll refer back to him in this way, I think one of the key aspects is that the schools themselves as institutions have not played a role in this evolving governance. It's been handed to them in a lot of cases by their conferences, by the NCAA, by a group of attorneys, as opposed to having their input shape this environment. And so they're in a position of what is the minimal amount of compliance that I can do to satisfy my stakeholders and to allow my school to remain in competition in this case. And I think as Rick even pointed out kind of wisely, how can I advocate for the athletes who I care about, who I have relationships with, who've chosen us? So we've fundamentally, and maybe disenfranchised is too strong a word in this moment, but we fundamentally given rules that aren't a part of this structure and don't necessarily and haven't necessarily been revised or pulled back to think about what the expanding present is. And I mean, NIL is, think of it in any way you want. I use the analogy, it would be nice if it were the same thing in each of the 4 years it has existed. But I describe this in this way, that it puts a different pressure on a different individual at the institutions in each of the years. In year one, it fell squarely on the shoulder of compliance. How do I make sure that the activity that my athletes are going to take on doesn't offend the NCAA rules that we've all agreed on, and the rules that we've thought about, and that it's truly separate from the institution? By year two, it fell squarely on the enterprise that it hit the fundraising director. How can we raise enough money to crowdfund back to our athletes and give them a version of salary? In year four, it fell on marketing and other individuals. And in this current year, where we're at now in 4.5, or where it's falling on your general counsel. How fast can your general counsel be to change the rules internally to allow you to move forward in this space, to create contracts, to pay, and to create it? So it's a vastly different field. And I think Rick typed it in. I'll say it because it's his phrase, and I've used it repeatedly. NIL is a social construct. It isn't a thing. It's a moving target that expands outward. I think that's a wise thing to say. But I think if the rules were focused, and if the rule book revision were to come, it would be focused on things that were pro student athlete, their well-being, their care, their graduation, and things that facilitated their careers, not things that kept lawsuits from happening in a different place or prevented power loss in another. So I do think it would need to be student focused, and that would be the one place where I think compliance has a future and a future role, is how do we take care of these people who are in this enterprise? Now, maybe employment at some point down the road will solve that problem, and compliance will turn into being the advocates for the athletes down the road. I don't quite know, but it is still one of the most important roles, and it's done by good people.
Joe and Don or Libby. Joe, I think you have your hand up.
Yeah, Rick did some history of NCAA and institutional control in institutions. I'd like to give a little more. He said everything changed. I think he said in 2020. I guess I'm going to disagree vehemently with 2020 is where it started changing. It started changing dramatically when conferences got more power and institutional votes weren't institutional votes. You voted within a conference, and the majority vote in the conference was the one that was carried to the management council. And I served on the management council. And I said over and over again, if there was a discussion at the management council that I thought was worthwhile, I had a pretty good idea where my institution would come out on it. And if we had gone out in with a preliminary vote that I was supposed to vote yes, and I was persuaded, I felt completely confident to change the vote to no. When you're one of 3 representatives of 14 schools, that ability to pivot when there's an argument that comes up is much less, you're much less able to do it. Now, I was pretty creative about it, because I would say to the 3 of us who were voting, well, if we all vote the other way, we now have a new majority vote in the conference and we can do it. But it became much more difficult. The other part of it is, I think we're looking back at the old NCAA structure as some, ideal. The schools that were less resourced voted consistently against bylaw changes that would have an impact on student athlete well-being, because they couldn't afford to do it and they were afraid there was going to be a competitive disadvantage. And I did a research project for the Knight Commission in which you can demonstrate that by where the votes shifted, and the votes were being pushed a lot of times by competitive interests, not student-athlete well-being interests. Now, I'm not saying that to say that we shouldn't go back to that, because I agree completely that the more we got away from it, the more problems that we've created, and the more it felt to institutions as though it was a top-down. But I'll add, nobody's mentioned presidents in here. A lot of this occurred when the presidents took control. I mean, they, on their campuses, rely on their executive assistant to advise. They got into conference government, and they relied on the conference commissioners compared to the people on the campus. So, I mean, we can point to how this happened in a million ways. How to fix it, I think, is really something that needs a lot of attention. And I agree with all of you who said this. I don't think you can just create a different structure for enforcement if you haven't changed fundamentally how we're going to make the decisions about what should be enforced and who should be the people making those decisions.
For sure.
Fair point. So I know Libby and Don, you've worked with numerous compliance people and been in and out of investigations. And Libby, you had your hand up. We'll let you comment on, how do you think this new world order is going to be going forward?
Well, it's certainly still very haphazard, as we've, kind of already talked about. I mean, the way legislation is made now at the NCAA often is through an emergency blanket waiver. It's through, as a result of litigation, House settlement, Avia lawsuit, other expedited rulemaking. The governance structure has been overhauled altogether, at the NCAA level. So it's less of the committee making that used to be very slow and methodical, the traditional legislative cycle. So I think to answer your question in terms of working with compliance folks, I'm sure that makes it harder, because you don't know if and when the rules are going to change and what they might be. So that, in turn makes your job more difficult, while it seems like there are less rules generally, because there's been deregulation even prior to the House settlement, deregulation of at least at the Division I level, a lot of the rules. So there's maybe less of the ticky-tack things on the books that can be time consuming for compliance folks. I would imagine it's somewhat chaotic for compliance folks to try to make sure that they know what's happening with the new rules, what's happening with the CSC, what's the latest court cases that are going to impact, what rules may exist from an NCAA standpoint, from a state law standpoint. So it's an interesting time.
For sure. Don?
David, even at the Division I level, we use that term Division I in a general sense, but we have low major Division I, we have mid major Division I, we have Power 4 or Power 5. You and I have had this discussion in different contexts over the years. At the low major Division I level, quite often you'll have one compliance person attempting to oversee 300 to 400 athletes, coaches, boosters, representatives of athletic interests. That's a dysfunctional system. At the mid-major level, you have slightly better staffed compliance areas. At the Power 4, Power 5 level, it's obviously considerably better. Even with the new rule structure, even though we've gone into some form of deregulation over the years and an effort to simplify the governance structure, still at that level, there are low major Division I athletic departments that don't pursue waivers for players. One of the things from my standpoint that quite often frustrates me, because of the fact that I'm so often representing the interests of student athletes, is to see student athletes or prospective student athletes that are sitting on the sidelines that I know could get a waiver and get on the field, court, pitch, or track. Quite often at the low major level, because of lack of time, lack of resources, or lack of knowledge, compliance staffs don't pursue waivers. That's a governance system that's broken. And even internally at the NCAA, and this has happened, and I've seen this happen in a number of cases over the last several years, cases that are beneficial to the interest of prospective student athletes when they pursue waivers are quite often archived so compliance staffs can't locate them. Several years ago, I represented this British soccer player. The young man came to the United States at 17. When he got to the U.S., the NCAA took 2 years of eligibility away from him, declared him ineligible. He sat out his first year, sat out his first year, played under the understanding that he was only going to have 2 years of eligibility. He played at a Division II school, then transferred to a Division I school. His family got me involved. We got the 2 years of eligibility back. Interestingly, a year ago, and that was about 8-9 years ago. Interestingly, a year ago, I represented another player, similar issues, and I referred the compliance staff to that case. The case had been archived. It wasn't available. The compliance staff didn't even have access to it. They knew nothing about it. How did I know about it? Because I was the attorney that handled the young man's case. So where do I see things from this point on with compliance? It will be the same. The under-resourced schools and the athletes and coaches and under-resourced schools will still suffer. Athletes, coaches, and under-resourced schools will still be the worst case scenarios in front of the Committee on Infractions. If you look at lack of institutional control cases, historically, the universities that quite frequently are hit with lack of institutional control are schools in the MEAC and the SWAC. Why? Not because of race, but because of money. They don't have the resources to fully staff. They don't have the resource. They don't even have the resources sometimes, financial resources sometimes, to be competitive. So the new system, I don't think it will benefit them in any way. And at the mid-major level, I think it'll be pretty much the same. And at the Power 4, Power 5 level, I think we'll see the same general outcomes from systems, a higher level of competition at the higher level, a lower level of governance and control and compliance with NCAA legislation at the lower level, not because of a desire to cheat, but because of a lack of resources.
Sure, and I definitely see that. Well, gosh, we could go on and on. There's some really great stuff, but we're already an hour in. We have about a half hour to go. So I'm going to go ahead and move to some questions from the audience because I think it will take up some time. And one of them from Paul Leiser or Leiser, I hope I'm pronouncing that correctly, Paul, is a question that I was going to ask. And it's pretty simple. We'll start with you, Libby. Can collective bargaining preserve educational missions while bringing stability to the rules, infractions, and enforcement system?
It's a great question.
I thought so too. Way to go, Paul.
Yeah. I mean, for what it's worth, I am, not a labor law attorney, but I think that we just saw, athletes.org issue their collective bargaining, framework recently, which is, starting the conversation. And again, that's been, an issue all along is that athletes haven't been involved in setting the terms of the conditions under which they're, for lack of a better term, performing their services, especially at this point, with some of our, some of the athletes in college sports. So I think that is potentially, a solution. I haven't read the athletes.org proposal through really thoroughly. I've just skimmed it. So I'm not super familiar with everything that's in there, but I think potentially that's a solution. I think the challenge is going to be, who are you bargaining with? What are our units? Is it all of Division I athletes? Is it all of Division I basketball athletes, men's basketball athletes? Is it football athletes? Because all of those interests are not aligned. There are some issues that all Division I athletes probably face, and things that they would all like to have, such as student athlete well-being issues, health and safety. Um, Considerations. There are some things that they could probably agree on. Others are very different. It's a step in the right direction, but it's extremely complicated, I think, in how you would actually execute that. Not to mention, conflict with some state laws that wouldn't even permit that. So. Um, we'll see. We'll see what happens there.
Rick, what do you think?
Well, I I just don't. All right. What first question would be, what is the purpose that we're trying to achieve here? What do what problem are we trying to solve, and does it solve it by doing this? Okay, whatever this is that people are saying collective bargaining. When I hear collective bargaining and I hear collective bargaining agreement, that's a labor law issue or a labor law function, whether it's state or federal labor law, it doesn't matter. Um, a collective bargaining in and of itself has it evolves under rights and obligations under the labor laws and what constitutes a mandatory subject and what's not a mandatory subject of bargaining, all these things. Um, and then, the collective bargaining agreement is something that can be enforced under rights and obligations that parties have under labor law. So to try to put this square peg in a round hole or whatever the phrase is. I mean, like that's what you have here. You're trying to like take this what works under labor law principles when you have a certified union and all that, and you're trying to put it into a collective bargaining, trying to do this with a non-certified labor union without labor laws trying to come into play. I'm asking myself, well, what are we solving and how are we solving that? How is it solving it? Because, people think that when you hear about collective bargaining and boy, wouldn't it be great if they're unionized? I mean, it doesn't solve any problems. It still wouldn't because, professional leagues and players associations, they have disputes all the time. They're called unfair labor practice charges, and there's grievances under that are brought and filed for all kinds of things. There's disputes in front of the NLRB over what constitutes a mandatory subject of bargaining. This you're not going to solve your enforcement problems or really provide stability. It's just going to create an agreement to the extent there ever is one. And to Libby's point, she's spot on. Okay, which is who are we talking about, and who's signing it? Who's you know, and who decides? I mean, we're back to the same issues and questions. Like, okay, does some committee or some person, all of a sudden say, hey, let's put together a collective bargaining agreement. I mean, that's just we're back to governance, right? Like, where does it come from? Where does it all evolve from? Bob, go ahead.
Yeah. Yeah, go ahead, Bob.
I was sorry, got that passed to me a little faster than I expected.
Yeah.
I think Rick is exactly right. Libby is too in a lot of ways. But if we were thinking about reimagining the system, and I don't think we should be thinking about anything less in this context, um, this is actually a job for Congress. This is actually where Congress could come in and pass something of a consensus bill that that granted a 4 or a 5 year exemption from antitrust lawsuit to allow a collectively bargain structure without employment or without but one with viewpoint in that could allow that to move forward. I see the problem of employment in the same way Libby sort of talked about. I think that's a process that won't help any current athlete and won't maybe even help anybody for about 8 or 9 years if we get to that point. So I see us as talking past each other a lot of the time, rather than talking about what can be accomplished in this construct as we go. And I think that would be the key that I think we would need to bring together conversations on. But if you're thinking about congressional enforcement, the idea of could we have a representative group in this space who could take on these problems, solve these rules, determine how we deal with the conflicts out of that, who's our referee, where's the adjudication of that, whether it's in court or whether it's in a special master proceeding or whether it's in an arbitration. Those things should not all be insurmountable, but ultimately they seem to be right now.
Joe, you want to comment on that?
No, I think I agree with Bob, and I also agree with Libby, and I also agree with Rick. I mean, the labor laws, the current labor law, I mean, they apply to private entity, not public entities, and a lot of our schools are public, not private. Some states have right to work laws. You'd have to decide what, and Libby's exactly right. Who would it be in what bargaining unit? It couldn't be all players at Nebraska or all players at Ohio State. It's going to have to be what, all football players, all football and basketball players. I mean, those are really tough questions. And I agree with Rick that the first question is, what are we trying to solve with it? If the issue is giving students a place at the table, there are lots of ways to do that. Maybe that's going to turn out to be the best way, but I don't know that that's necessarily true because I don't know what we've tried to give them a voice. I will say that when student athletes were put on committees, and that's a pretty recent phenomenon, and given votes at to votes on when we were still voting on policy and legislation, they tended to listen to the AD and the compliance director and the advisor at the school. So they weren't making an independent decision based on talking to others. I mean, they're kids. And they looked to the people that they trusted. And I'm not saying that it was ill-advised to trust them, because I do think that athletics directors and coaches do try to do what's in the best interests of their students. Not all of them. I agree with Don that they're going to be outliers here, but most of them are interested in the well-being of their students. But if we're really talking about giving them a voice, it doesn't seem to me that you get there if they're just going to go to the people at the school who are making the decisions anyway, who will then tell them, here's what we think is the best way to go, and then they vote that.
Don?
David, in my other life and in my predominant life, I'm more involved in professional sports than I am in college sports. So the things that we can resolve through collective bargaining are health benefits, protection of the right to a credible education, which I will be frank with you, quite a number of student athletes on the campuses of even major universities are not receiving credible educations. I was involved in a case several years ago involving a student athlete that was banned from athletic study hall. He was banned from athletic study hall. And all of his courses were online courses. And then he was expelled for academic fraud. Banned from athletic study hall, all courses online, expelled for academic fraud, protection of rights to a credible education, protection of economic rights. All of the discussion that we're having involving student athletes revolves around one basic issue: the absence of a property interest or a liberty interest in their athletic eligibility. Let's just be perfectly candid about this. Athletic eligibility or athletic participation, even for, quote, amateur athletes, athletic eligibility has an economically quantifiable value. And that economically quantifiable value, in the same way that if a city wanted to build an airport over your house, they're going to have to condemn your property and pay you for that property. If your athletic eligibility is going to be taken away, or you want to be deprived of it, that has a value. All of the things that we're talking about and the concerns about collective bargaining, let's let's accept this one fundamental fact. Student athletes meet all of the criteria for employment. The Waldrop case involving a player from TCU that was paralyzed in a game against University of Alabama decades ago, tried to get workman's comp. In order for him to get workman's comp, he had to establish that he was an employee first. Initially, he won at the lower level. Ultimately, he lost. Well, eventually, a court, and that could happen in one of the pending cases right now. Eventually, a court is going to determine that student athletes meet all of the characteristics of employment. When that happens, this whole commission structure, it's all going to go up in smoke. It's going to change everything, even about the commission. When there's a determination that student athletes are employees, then it's going to shift the paradigm to a point where the NCAA, conferences, universities are going to have to collectively negotiate issues of employment with them. I don't see that as a bad thing. There's no need for a 4 or 5 year statutory exemption to antitrust law, because this is it. When you collectively bargain, you have the right to violate antitrust law.
Exactly.
Salary caps are a violation of antitrust law. So it all gets down to a fear of affording student athletes a credible place at the table. There was a case years ago involving a Creighton University basketball player. He played there for a number of years. He graduated, and at the time that he graduated, he had a third grade reading level. And he wound up going to Marvin Collins School in Chicago because literally he couldn't read. He filed a lawsuit against the school for negligent admission and educational malpractice. He lost. These are the things that a collectively bargained agreement between student athletes and management, NCAA conferences. These are things that could be collectively bargained. I don't see that as a bad thing, and I don't think it would be that difficult to establish bargaining units in order to get effective agreements between parties.
No, I tend to agree, and I know we could talk about this one a little bit more. So, Rick, I'll give you a chance in the follow-up notes, but as we are getting close on time, I do want to go to Joe, and I'll come to Don and Libby on this one, and then give Bob and Rick a chance. But question from Donna Lopiano, and one that I wanted to ask too, is will arbitration, and CSC has talked about this in their enforcement, arbitration, required or voluntary, offer any kind of an enforcement solution if it's based upon full allegations and evidence, gives people the right and opportunity to be heard, those types of things that maybe get to the heart of due process issues that have often been criticized in the enforcement process. And we'll start with you on that one, Joe.
Yeah, well, sports traditionally has gone to arbitration, not litigation. That's the model in professional sports. It's the model in Olympic sports. They've got the Court of Arbitration for Sport, which is an arbitration function. So it seems to me that better that than running into courts who do not tend to not have the same expertise, and they vary from state to state to try something like that. Whether it will work or not, I still say I don't think the mechanism for deciding is as important as who's making the decision and what is it we want to decide. And I don't think we're there. I mean, I bet if you tried, I don't want to bet, but I don't want to be, but I bet I did it again. If you asked 150 schools, the Power Four, and then you pick others, not the general, I mean, at the macro level, everybody agrees, but how to do it. I don't think there would be enough consensus to get a majority vote on anything right now. And I said I started out as a Debbie, did whatever I said at the beginning. And I still say it. I mean, I sat in those meetings for a long time, and the variety of views, and most of the time they were well thought out, sincere views that were not in space. They really were looking at educational issues, but there was such a difference in how they came to the same subject. That's where I think we have to start. If we got that done, then you could find a structure to handle it. And I think that would be the easy part, finding the structure to do it.
Libby?
I agree. Yeah, I agree with Joe in terms of finding the structure. I think you're still going to see challenges to the CSC process, um, moving forward because there's still disagreement about what the rules are, what they should be, how they're applied, how they're enforced, who they're applicable to, along with all of these other issues that we've already talked about that impact some of the very issues that, the CSC is now tasked with enforcing.
And Don, your thoughts on independent arbitration?
One of the things that will be subject to arbitration will be the fair market value of, I'll call them endorsement agreements because I'm coming from professional sports. And the CSC will have the authority to make determination on the fair market value of endorsement agreements. I can tell you in advance that these cases will wind up in court. They absolutely will wind up in court. Fair market value is a relative concept. It's a concept that values from city to city, from state to state, from urban community to urban community. Back in 2002, I represented a professional soccer player in the WUSA. She was the first player to be suspended for wearing an improper logo on team premises, on league premises. She scored a goal. She lifted up her shirt in a game and displayed the logo of a product endorser. She made more money from that endorsement likely than she made from the league. So what's the fair market value of that? She gave that company national exposure. She actually gave that company international exposure because she was an international athlete. Issues like that, although we've got the Court of Arbitration for Sport, even cases that go through the Court of Arbitration for Sport ultimately wind up in the Swiss federal system. Castro Semenya, an African athlete that suffered from hyperandrogenism, her case ultimately wound up out of the Court of Arbitration for Sport into the Swiss federal system. I'm not a fan of arbitration, as you can probably tell, because it all depends on who's selecting the arbitrator. In the NFL for years and years and years, the arbitrator and the ultimate decision, the arbitrator was selected by the commissioner. Arbitration decisions were appealed to the commissioner.
Right.
So exactly how's that going to work? And then quite often those cases wound up in the court system. I don't see the concerns to subjecting the collegiate system to the same set of rules and laws, both state and federal, that every other industry in the United States is subjected to.
No, I think that's fair. And I'm gonna, as we're moving along here, I want Bob and Rick to have a chance. So Bob, I'll give you a chance, but I want you and Rick to also, if you're able to, add on to that. Do you think that the governance structure going forward, this is from Leonard Genova, the governance structure going forward for Power Four schools and the rest of the NCAA members should be the same, or should that even be different? We've heard about Power Five separations and things like that before. What are your thoughts on that?
I'll take that one first, and given my long-standing relationship with the questioner, I should probably take that one. I don't necessarily see the concentration of the Power Four at the expense of everyone else necessarily as positively as some do. An ironic thing for someone to say who represents conference commissioners, including a couple in that group. But I don't mind having the rules generally be the rules if they were similarly agreed upon. I think the problem is that the Power Four want to set up the rules for themselves that advantage themselves. So they basically want to play the home game and bring the referee. And I think that's kind of the problem in that process. I feel like the fundamental problem of governance is we're not willing to be statesmen and stateswomanly enough in this moment to provide a broad answer. We only want the answer that benefits us in this moment.
Okay. And Rick will give you probably the last word here. You can comment on arbitration, but you're at Eastern Michigan University. Should Eastern Michigan athletics be governed a different way than University of Michigan just down the road?
My short answer is no. I think I think that it's interesting. I got a lot of thoughts in my head right now, but and how to answer this. We have at the conference level, we meet as FARs, and we develop policy at the conference level. And I actually, as the FAR at Eastern Michigan, I'm sitting on the and our conference actually has its own infractions committee where we look at within the conference and like the NCAA infractions committee would do at the NCAA level, we do it at the conference level too, which is sort of unusual. And I think any system of governance, it really revolves around this question of where is the incentive to report violations, right? If you're the institution, do you have that, incentive to do it, and making ensure that as a conference that we create mechanisms to make sure everybody's doing that, right? And following the rules, whatever the rules are. And I think that at the conference level, applies at the NCAA level, Division I as a whole. The other thing I just want to add is we've been here before. It's really not that different, right? I mean, Joe, let's go back further than 2021. Okay. Let's go to 2014. With the autonomy provisions, right? So, we had this same issue with the Power Four wanting to do their thing differently from, the rest of the group, member institutions in Division I. But I would also say to Joe, look, there was a vote. They voted on that at least, and they created those autonomy provisions as opposed to just the Division I board waking up one morning and going, we've decided that autonomy provisions make the most sense. And
I mentioned presidents, remember?
Yeah. Well, and I have to tell you, I feel horrible. This has gone much quicker than I thought. There's so many more questions I wanted to ask, and some great questions by the panel. I see Dan Rasher and a lot of others have asked some really good questions, which we will respond to in the follow-up notes. But I do want to thank the panel. Julie, if you want to jump back on, or Becca, whoever needs to close us out. But again, thanks to the panel. Thanks to Don, Libby, Rick, Bob, and Joe. Fantastic stuff. I really, really enjoyed it. And we will get the follow-up notes, and this recording will be posted. I think, Julie and Libby, if that is it, you have anything you want to add, or am I able to close out the webinar myself?
You good. Close it out, Dave. You're good.
Okay, thanks so much. I want to make sure. Again, thanks to everyone. Really appreciate it. Good
Thanks,
stuff,
everybody.
Good grist for the mill, and we'll keep on addressing these issues and solve the world's problems, I hope. Thanks again, and recording will be posted soon. Thank you.
Thank you.